So who's going to be in charge of Anne Heche's estate? My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. And today we're going to talk about the most recent in the long line of celebrities who've died and left behind a total mess when it comes to sorting out their estate. Now, when we see these stories hit the news, we always wonder, how can celebrities still do this? I mean, there have been so many stories recently. When I went back and looked at some of my files, we have Naomi Judd cutting her daughters out of her will. Tupac's estate is fighting over an NFT. Tom Petty's children fighting with their stepmother over control of his catalog of music. George Jones's estate, where they discovered lost tapes from his that now they have to figure out who controls them, who owns them. Here in Minneapolis, we've had Prince's estate, trying to figure out, first of all, what it's worth so the IRS can get paid, and then after that, also, who's going to be in control, who's inheriting his assets. Larry King used a handwritten will to divide his estate up, and Tony Hsieh, the former founder of Zappos, died with a wall full of post-it notes supposedly detailing charitable donations he was planning to make. And of course, on the other end of the spectrum, we have folks like the Queen of England, Rick Ocasek, Kirk Douglas, and David Bowie, who all had very clear estate plans in place so that none of these kinds of things are going to hit the news about them. So in Anne Heche's case, what we're finding out now is that she died in August and she died without a will. She leaves behind two sons, a 20-year-old and a 13-year-old. The 20-year-old, named Homer, is asking to be the administrator of her estate. The father of the 13-year-old, who's named Atlas, is contesting that. He wants to be the administrator of the estate, not Homer. So what the court is currently trying to figure out is who is going to be the administrator of Anne's estate. So supposedly there's a 2011 email from Anne to Atlas's father, James, asking him to oversee her estate if anything happens to her. So her assets should go to him, and he would then divide it amongst the two sons, with each son getting their inheritance at the age of 25. However, James claims that Homer should not be the administrator of the estate because he's only 20 and he's too immature, and he's not ready to be the administrator. So this is important because when you have someone like Anne, who's been in movies and has upcoming projects, supposedly she has a book that's about to come out, we need to make sure we have an administrator who can take care of all these upcoming projects that need to be released and be the person to administer and deal with copyrights and deal with the profits that come from that. But by not having a will, or having the will solely be a 2011 email that was supposedly sent to the father of one of her children, Anne is left quite the conundrum, quite the situation that court's going to have to figure out. So the question is, if she'd been to an attorney, what should she have done instead? Well, first of all, we need a guardianship provision for Atlas. Atlas is only 13 years old. He has 5 more years till he hits the age of 18, so we want to make sure we have a guardianship. So we want to have a will that says, as long as my children are under the age of 18, here are the people I would want to be the guardians of my child. And along with the guardianship, we would also want a trustee appointed for that child who's under 18. So Homer doesn't need one. He's over 18. He's 20 years old. But for Atlas, who's only 13, we want to make sure we have a guardianship provision and a trustee to manage funds for them. Especially in Anne's case, where the estate could be significant, you don't want to give millions of dollars to a 20-year-old, and especially not to a 13-year-old. In Anne's case, you also would have wanted an estate plan, so we'd have somebody appointed as the administrator. So right now we have a dispute between a 20-year-old son and the father of another child. And what the court now has to go through is figuring out which one of these two is appropriate, is the right person to be the administrator of her estate. The smarter way to do it is to create an estate plan, create a will that would appoint somebody as administrator. In the case of someone like Anne, she may have even chosen a business manager or someone else she works with who's familiar with her business dealings, familiar with her projects, and would be the best suited to be the administrator of the estate. And then the third thing we could have done is actually create a trust. So if Anne was really concerned about her children inheriting money from her and holding that until the age of 25, what may have made sense for Anne would be to create a trust-based estate plan where all the funds in her estate go to the trust, and the trustee can manage it for Atlas and can manage it for Homer. So let's say Atlas is going to go to college in about 5 or 6 years. The trustee could manage the money in the estate to make sure that college expenses are paid for, and then at the age of 25, whatever's left in the trust could be distributed to Atlas. In the case of Homer, at the age of 20, same thing applies. Maybe he's going to school, maybe he has other needs, and then the trustee can manage the money for him, and then when he hits the age of 25, it can be distributed to him. Hopefully you can see that celebrities have the same problems the rest of us have when it comes to estate planning. A lot of them never get around to it, and then you're left with these stories. Now, the difference is if it happens to you, chances are it's not going to make international news. It's not going to be the front page of a website that you, John Smith, died without a will. However, the issues are still the same, even if they're not all over the news. So rather than try to do it yourself, don't just send an email from about 11 years ago claiming to be your will and what you want to have happen. Create an estate plan. You want to work with the professionals, work with an attorney, work with your financial advisor, work with an accountant to put together a plan. Especially when you have children under the age of 18 like Anne did, you want to make sure that you have a plan set out for them so they're not left adrift without any guidance of where to go. If you're ready to get started, you can set up a legal strategy session with me. Go to my website, andrewmayers.com, and there's a red legal strategy session button on the front page. You'll be taken to my personal calendar, and we can set up a 15 or 20-minute phone call to go over where you are in the process, whether we're updating an old estate plan or starting fresh or creating a new one. We want to make sure that you know your options and have the best way to plan for your legacy.